So, for those of you who may well be unfamiliar with the case of FCA and Arch Insurance UK Limited and others, it was essentially a test case brought by the Financial Conduct Authority to obtain clarity for the maximum number of business disruption policy holders and their insurers as possible in the wake of the ongoing pandemic. In numeric terms, it's estimated that there are 700 types of policies across 60 insurers and 370,000 policyholders. It may well be, though, that that's the tip of the iceberg, because the litigation was limited to policyholders, namely SMEs. There are, of course, implications for consumer policies, for example, holiday cancellations, weddings and other events, income protection insurance for the self-employed, payment protection insurance for mortgages and secured loans, and landlord insurance, all of which are likely to be influenced by the decision in some shape or another. As to the judgment itself, if you haven't had time to read it, it's somewhat lengthy. It's 96 pages in length and about 320 paragraphs. It is preceded by an equally detailed High Court judgment of 580 paragraphs. And obviously, it's not going to be possible in this time to deal with the entirety of those judgments and the minutiae contained therein. So consider this the highlights, as it were. It's also necessary to give a health warning in that of the 60 insurers and 700 policies that I've referred to already, the case considered 21 policies. It's worth bearing in mind then that the test case and the results of the test case is not determinative of every policy, and there is likely to be future clarification issued piecemeal by the courts, if indeed they get litigated to the authoritative courts. And rather, the way that I would perceive this is that it adds another layer to the practitioner's interpretation arsenal. The court didn't reinvent the interpretative wheel, as it were. Turning then to the test case, the judgment deals with the interpretation of the following clause types: disease clauses, which are clauses which provide cover for business interruption losses resulting from the occurrence of a notifiable disease; prevention of access clauses, which are clauses which provide cover for business interruption losses resulting from the public authority intervention preventing or hindering access to business premises; hybrid clauses, which are clauses which combine the main elements of disease and prevention access clauses; and finally, trends clauses, which relate to quantification of business interruption losses with reference to what the performance of the business would have been had the insured peril not occurred. The appeal also raises the issue of causation, which Stephen will address shortly, alongside the court's findings with regards quantification and trends clauses. I don't propose to go through the factual background. We all lived through it. However, it is worth noting that at paragraphs 6 through to 35, there is a significant amount of detail surrounding the emergence of the coronavirus and the government's response to the virus. And that provides a useful chronology, not just for this case, but for cases moving forward, in which the relevant statutory framework may well be relevant, and the timings of that may well be relevant also. Turning then to the disease clauses, the principal disease clause that was considered by the Supreme Court read as follows: "We shall indemnify you in respect of interruption or interference which the business during the indemnity period following any occurrence of a notifiable disease, defined as any human infectious or human contagious disease at the premises. Occurrence of a notifiable disease within a radius of 25 miles of the premises." Dealing first with the issue of notifiable disease, the court concluded, adopting the perspective of a reasonable reader, that this referred to a notifiable disease as classified by the Health Protection (Notification) Regulations 2010, under which a registered medical practitioner has a duty to notify the local authority where the practitioner has reasonable grounds for suspecting that a patient has a notifiable disease. COVID-19 was so designated by the 6th of March 2020, and that's a finding of fact that's carried over from the High Court. One may question how many policyholders are actually aware of that provision, of those provisions, but it does give a strong indication as to when the courts are likely to conclude that the relevant indemnity period has commenced, subject, of course, to policy phraseology on a policy-to-policy basis. Turning then to the interpretation of occurrence, or a notifiable disease within the geographical limits prescribed by the policy, the court again preferred an ordinary interpretation of the words used, and occurrence, like its synonym event, has a common meaning in insurance law, namely something which happens at a particular time, at a particular place, in a particular way. On that basis, each case of illness sustained by an individual in consequence of COVID-19 constitutes a separate occurrence. And in the case of the RSA 3 policy being construed, within a 25-mile radius meant exactly that. Each case of an illness sustained by an individual within a 25-mile radius was an insurable event. Now, unsurprisingly, the RSA 3 policy wording, as with many policies, sought to exclude liability for losses if the disease amounts or amounted to an epidemic. The exclusions section commenced at page 91 of the policy wording document, and the particular exclusion relied upon appeared 93 pages thereafter. Now, I don't know whether or not my facetious tone will get conveyed through this Zoom meeting, but I adopt that tone for a good reason, and it's because the location of that exclusion was a particular sticking point for the court. As to the wording, in the usual way, the insurance by this policy does not cover any loss or damage due to epidemic and disease. Counsel for RSA in the Supreme Court sought to invoke the usual presumption that when faced with two apparently inconsistent provisions, the court should start from the presumption that the parties intended that effect should be given to each of those provisions and that the court ought to reconcile them. One can see the logic in that position. The parties must have intended protection for an unexpected outbreak of a notifiable disease, but at the same time, it's understandable from a commercial perspective that the parties would agree to limit that protection to isolated events rather than widespread disease, which of course are much more significant losses and therefore much more significant effect potentially on the insurers. The court didn't agree with that proposition and stated that such a presumption would only be a sound starting point where the parties to the contract would reasonably be expected to have both clauses in mind simultaneously. On the instant policy wording, the reasonable reader would normally assume that if the intention had been to put further substantive limits on the risk of business interruption specifically insured, that would have been done transparently and as part of the wording, a part of that extension, and not buried away in the middle, or in this case at the end, of general exclusions. It seems then, to me at least, that any such exclusion could be effective subject to the location of that exclusion within the policy. But this particular finding may also be particularly significant for the interpretation of insurance policies generally, which include a similar raft of exclusions. I suppose we'll have to wait and see. Turning then to prevention of access and hybrid clauses, I deal first of all with the findings in relation to prevention of access. And in order to do so, it's necessary to consider an example, in particular the one that the court considered, which is taken from the RSA 1. And it recites as follows: loss as a result of closure or restrictions placed on the premises, as a result of a notifiable human disease manifesting itself at the premises or within a radius of 25 miles of the premises. Of course, the first half of that deals with prevention of access, i.e. loss as a result of closure or restrictions placed on the premises. And the hybrid element comes from the latter part, which of course is very similar to a duplication of a disease term. For the sake of brevity, the disease elements were construed in the same way as a disease clause, i.e. each case of a disease constitutes an occurrence, and any intention to restrict the area of such an occurrence would have to have been made explicit. As to the restrictions imposed, the court concluded that restrictions imposed by a public authority would be understood as meaning mandatory measures imposed by the authority pursuant to its statutory or legal powers. However, the enactment of such powers is not strictly required. Rather, an instruction given by a public authority may amount to a restriction imposed if, from the terms and context of that instruction, compliance with it is required and would reasonably be understood to be required without the need for recourse to legal powers, albeit such an interpretation would of course likely be limited to such a state of affairs as are created during the course of an emergency such as this one. The said restrictions are not required to be aimed directly at the policyholder, and indeed may arise because the public have been told to keep out of the building, refrain from a particular activity, thereby resulting in loss arising out of restrictions placed upon the property's use. Finally, as to the extent of the policyholder's inability to use, the court concluded that the requirement is either met if the policyholder is unable to use the premises for a discrete part of its business activities, or if it is unable to use a discrete part of its premises for its business activities. It is a broad interpretation which offers a significant degree of protection to policyholders. And the only caveat to note, which stems from a concession made by the FCA, is that the cover only applies to the part of the business for which the premises cannot be used. For example, a restaurant which offers takeaways, which closes its entire business, would only be entitled to claim in relation to the restaurant part of the business and not the takeaway aspect, which could of course remain open. I am now, through the miracle of video editing, with any luck, going to hand over to Stephen Turner, who will conclude the talk by talking about causation and quantum.
So to summarise, the court's conclusion on interpretation was that the clauses do respond, but only in respect of the effects of COVID-19 cases occurring within the specified radius, usually 25 miles, but obviously dependent upon the terms of the individual policy. Now, that finding in turn raised a critical question in relation to causation. If the policy is to respond, what connection needs to be shown between those particular cases within the radius and the losses sustained by the business? Now, that proved to be a surprisingly complex question to answer, with a full 90 paragraphs devoted to answering it. I'm going to try and distill those 90 paragraphs down into about 20 minutes. So bear with me. There'll inevitably be an element of skimming over things, but I hope it will give you an indication of the views of the court. So the starting point. The first thing to do is identify the proximate cause of the loss. And in doing so, the court said that what needs to be applied is a common sense interpretation of both the events that occurred and the wording of the policy. The answer to questions of causation is unlikely to turn on the precise wording of the particular clause. So whether it says losses following, losses incurred as a result of, losses arising from, that's unlikely to make a difference. The court gave an example of what it meant by the common sense approach, referring to the case of a ship torpedoed in wartime and then towed to port and moored in the outer harbour of a port. The ship sank 3 days later due to pretty unexceptional wind and wave conditions. Now, under the terms of the policy, perils of the sea were covered, but enemy action was not. Now, on one view, it was the sea state that sank the ship. If the sea hadn't been as it was, the ship wouldn't have sunk. But what was the proximate cause when you stand back and apply common sense? And the answer, of course, was the torpedo. Had the ship not been torpedoed in the first place, the sea state would not have presented a problem. That means that the proximate cause for the purpose of the policy was the torpedoing, which was an act of war, and so the loss was not covered. Now, that is an illustration of concurrent causes combining to cause the same loss. Neither cause would have sunk the ship by itself, but the ship still sank. And the court pointed out that there's a general rule in relation to such cases. If one cause is insured against, where you have concurrent causes, and the other isn't, the insurer generally will have to pay. But if one cause is insured against and the other is specifically excluded under an effective exclusion clause, then the insurer generally will not have to pay. Now, the court held that such a concurrent cause analysis was the appropriate approach to adopt here, with each individual case of COVID being treated as a separate concurrent cause. None of those individual cases would have caused a loss by itself, but each was a proximate cause of the loss and so relevant when considering questions of causation. It did not matter that that approach would lead to there being hundreds of thousands of potential concurrent causes. The analysis still held good. But a concurrent cause approach then leads to a complication with the standard but-for test for causation. The insured peril, on a proper interpretation of the policies, it was found, of course, was COVID cases occurring within the defined radius, the 25 miles. But then look at that on a but-for basis. If those cases had not occurred, and all cases had occurred outside of the 25-mile radius, the government would probably still have imposed national restrictions and enforced closure on properties within the 25-mile radius. So the losses would have been incurred in any event. They would have been incurred but for the insured peril. So how could you say they were caused by the insured peril when they would have been incurred anyway? So if you were to take a simplistic but-for approach to causation, the policies wouldn't respond. But needless to say, the Supreme Court regarded such a simplistic approach as unsatisfactory. The court pointed out that there were well-recognized inadequacies in relation to a but-for approach in cases where there are multiple concurrent causes, none of which would by itself cause the loss. It gave the example of a decision by members of a company board That decision is carried with a big majority. That decision causes loss. Now, the vote would have been carried, but for the vote of any single member. You could take any individual and take them out of the situation. The result would be the same. But they said you can't sensibly say that each individual member's vote was not a proximate cause of the loss. And so the but-for analysis is not going to provide an answer in cases of multiple concurrent causes, such as the present. They also objected to that analysis on the basis that effectively what it did was pit instances of the same cause, COVID, which occurred outside of the geographical radius, against instances of the same cause, COVID, which occurred inside the geographical radius. It said that can't be right and wouldn't have been and couldn't have been the contractual intention of the parties. So the but-for approach rejected. The insurers also tried as an alternative to argue for a weighted approach to causation. And what they said there was this, that only if the percentage of cases inside the radius was significant should it be found that those cases constituted a proximate cause of the loss. That approach was again rejected. Firstly, because such an approach would be unworkable in practice. What proportion are you going to set as your threshold? What is or isn't significant? But more fundamentally, as with the but-for test, the approach once again pitted cases of COVID outside of the insured radius against cases inside the insured radius. And the Supreme Court said the policies couldn't logically have been intended to operate where you take one aspect of something to undermine payment in respect of another aspect of the same thing. So what they said was that the answer was to adopt what was called an individual case analysis to causation. That is an approach which treats each individual case of disease as a separate and equally effective proximate cause of the restrictions and interruption to the business. That solution was preferred, they said, not least because it was simple and would be easy to apply. Note, that's a decision smacking as much of policy as of principle. And the position ultimately, if you're looking for a single paragraph that encapsulates it, was summarized at paragraph 212. So if I can just read you that. We conclude that on the proper interpretation of the disease clauses, in order to show that loss from interruption of the insured business was proximately caused by one or more occurrences of illness resulting from COVID-19, it is sufficient to prove that the interruption was a result of government action taken in response to cases of disease which included at least one case of COVID-19 within the geographical area covered by the clause. The basis for this conclusion is the analysis of the court below, which in our opinion is correct, that each of the individual cases of illness resulting from COVID-19, which had occurred by the date of any government action, was a separate and equally effective cause of that action and of the response of the public to it. So a concurrent cause analysis with the presence of one case within the defined geographical area being sufficient to engage the policy. The court then moved on to look at trend clauses. Now, these, of course, are a standard way of measuring loss under a business interruption clause. You look at the previous performance of the business and you adjust for business trends to ascertain what the performance would have been but for the occurrence of the insured peril. Now, this was effectively a fallback argument for the insurers, an attempt by them to avoid paying by the back door. Their argument was as follows. What would the performance of the business have been if there had been no disease within the defined 25-mile radius? Answer to that question, the performance would have been the same as if there was disease within the 25-mile radius. There would have been no earnings, as there would still have been lockdown and the other measures which interrupted the business. So even if the policy is engaged, as the court found that it was on its interpretation of the policy wording, there would be no loss, because a comparison with what the business did earn with what it would have earned if you hadn't had a disease within the 25-mile radius brings you to the same figure. Nice try. You may see why inevitably that approach was rejected. The court thought the solution was simple. When you are analysing and interpreting a trend clause, you must exclude any trends arising out of the same underlying or originating cause, but you must still include and take into account other trends which have affected the business. The underlying or originating cause in this case, of course, COVID-19. Also, when looking at trends, you should exclude any discrete part of the business that has not been interrupted by the insured peril, paragraph 281. Now, the example they gave was of a fashion retailer that sells in a shop and online. The shop is forced to close, but online business carries on. So how, under the trend clause, do you work out the loss? Firstly, identify the activities affected by the insured peril. Secondly, identify the earnings from those activities during the affected period. Thirdly, compare those earnings with standard turnover adjusted to reflect trends generally or specifically, but not trends related to COVID-19. Now, it's interesting also to note a possible byproduct effectively of that approach as set out at paragraph 286. So on the court's analysis, you have to exclude discrete parts of the business which have not been interrupted by COVID-19 from your calculation. So if website orders carried on uninterrupted and they increased or fell, you would leave that out of account. Now, query whether that could result in a windfall for businesses which saw displacement from bricks and mortar sales into online. If the discrete online aspect of the business are left out, the business doesn't have to give credit for the upward trend in online sales, but it can still claim the full extent of losses under as a result of bricks and mortar closure. Finally, the court dealt with the question of pre-trigger losses. So say, for example, under the terms of the policy, the trigger for loss was enforced closure under a closure order. But in the weeks leading up to that enforced closure, that order, business performance had been depressed by COVID-related factors such as stay-at-home advice or general public concern with catching COVID. So you have depressed turnover, but it's pre the trigger date, prior to the loss being triggered under the policy. the question arises, do you include that depressed pre-trigger period when calculating turnover but for the insured event? The Supreme Court said, no, you don't. As with trend clauses generally, the correct approach will be to disregard any COVID-related effects, even if they occurred prior to the trigger date. So that is a skim through the court's decision on causation and a few ancillary related issues. The parties have been left to agree forms of declaration, and those are awaited. It will be interesting to see and study those once they're received. But now, so far as our talk's concerned, if we return to the main lobby, Adam and I will hold a quick Q&A with any contributions from attendees welcome. Thank you.